In today's tense courtroom drama, frustration boils over as defense counsel pushes for access to crucial probation records in the case of Juan Sanchez. What begins as a legal argument over discovery quickly spirals into heated exchanges, forcing the judge to step in with sharp warnings. Will the defense's aggressive strategy secure vital evidence or risk backfiring on their client's future?
You seem very frustrated, and I'm not sure why. And the last thing you want to do is talk over me.
Yes, sir.
So I'm sitting here saying that I agree with you, and you're still being argumentative, even towards me. And that's not going to get you anywhere. Hold on. Being argumentative with Mr. Nichols isn't going to help Mr. Sanchez. Being argumentative with these ladies isn't going to get you anywhere. I agree that you're entitled to this information. I just think there's a better, less argumentative, defensive way to do it. They were told to do what they were told to do because their understanding of the law is what it is. Nichols, Mr. Franklin, on Juan Sanchez. All right,
The judge begins by clarifying the central issue, whether a subpoena duces tecum, a legal order typically requiring documents at a scheduled hearing, was the right tool. The ruling, it was. But here's the twist. While the defense may have used the wrong legal mechanism, the judge firmly acknowledges that Juan Sanchez is still entitled to much of the information.
This is cause number 1830854, and sir, you're Juan Sanchez?
Yes.
And so we're here today on a motion to compel, and before we get into a whole lot, I've done a lot of my own research and looking at all of this, and a couple of things. One, I don't believe the subpoena duces tecum was the proper way to try to get the information. Duces tecum is an order to get somebody to bring something to a set hearing. So we didn't have a set hearing, and they weren't ordered to give it to at a set time for a hearing. So under the rules that have to do with subpoena duces tecum, I don't know that that was the proper way. I do think you're entitled to some of that information as a defense attorney. If we're going to base decisions on, if I'm going to base decisions on things that probation have in their file and that they're just going to tell us, I do believe that you are entitled to some of that information. I think the proper way to do it would be to make that request through the district attorney's office for discovery. And then for you, Mr. Nichols, to make those requests. And then I would approve you guys giving whatever records are requested within reason. If you have, I don't know what would necessarily be any type of work product that would not be discoverable, but if you think that there's something that is particularly not discoverable, let Mr. Nichols know that, Mr. Nichols let me know that, then we could worry about maybe a motion to compel and whether or not I think those things are or are not. But lab results of testing, money owed, all of those types of things, I think are probably discoverable and something that Mr. Franklin needs. I just don't think this was the...
I agree, Judge. Any of the things that pertain to, well, I do think it's discoverable. In this case, it's all allegations on the motion are based on arrest out of county. And so his attendance record and all that, I don't know why we're subpoenaing the entire probation file when it's not even part of the allegations for the motion.
May I respond, Your Honor?
Well, let him finish, yes.
He did subpoena Wharton County records, so a representative from probation down there came in today for this hearing.
As discussion continues, the prosecution takes the stand figuratively to say, we don't oppose giving the records, but much of it isn't even in our possession yet. The prosecutor emphasizes that these are out-of-county offenses, meaning the necessary reports haven't been obtained. This paints a classic courtroom dilemma. The defense needs evidence to prepare, but the prosecution cannot hand over what it doesn't have. It's a legal game of hurry up and wait.
I have no problem with getting him all that stuff. A lot of it's not in my possession. The out-of-county offense reports and things like that, I don't have yet. I would have them if we move towards a hearing where I prove up those allegations, and they, of course, will be provided beforehand. And again, I don't think he's not entitled to have all that stuff. So
Sure.
I kind of agree with
So-
the subpoena directly to those agencies was the proper way to do this. And Mr. Franklin did make just a standard discovery request at the onset of his involvement, which was early May.
Right.
I don't have anything really responsive to that at this point.
Okay. So obviously, if it's based on a new offense out of another county, that's something you'll need to work towards
Right.
getting and get that to Mr. Franklin. And so that needs to take place as quickly as possible. Let me look at the motion itself. Because I don't know, I guess, Mr. Franklin, if there's not an allegation in the motion to revoke with regard to certain administrative violations, and there isn't an allegation, then why would you, what is your argument that that would be relevant or discoverable?
Now the defense shifts tactics, making a strong plea. Performance on probation matters. Juan Sanchez has been on probation for nearly 6 years, a major point in his favor. Payments, reporting, compliance, these could all persuade the court to grant him another chance. It's a smart strategy, highlighting rehabilitation over punishment. But here's the question for the audience. Should a long record of good behavior outweigh one new violation?
Your Honor, my client is wanting to stay on probation, and the court may take into consideration his performance while on probation, including his payments, his report, and everything else. So as part of determining the motion to revoke, it is relevant to look at his performance while on probation, particularly when he is requesting to stay on it. And he's been on probation nearly 6 years, I think over 5.5 years, nearly 6 years. And that performance will be helpful in determining or mitigating whether he stays on probation or if the court decides that he goes off of probation, and perhaps mitigating any potential sentence.
Okay,
And
I don't
so-
disagree. So, again, though, I think the way to do it would be to make that request. I mean, and I don't know what conversations y'all have had, but make the request. I think coming at it aggressively might not be the way to do it. Sometimes you get more with honey than otherwise. So make the request to Mr. Nichols. If he says no, then let's go through what we need to go through. But let's try to do this amenably. The ducis tecum is not the way to do it unless it's set for a hearing. That's just the rules of evidence. And
Yes, Your
so
Honor.
that's not the way we're going to do
The
it.
ducis tecum was set for the day that it was initially set for a hearing, and it did specify that date for the hearing, I believe. And we ended up moving the hearing date because of conflict.
And Judge, I'd ask Ms. LeBeau to go ahead and get everything together today
Yeah.
to turn over.
I mean,
Unless
yeah,
there was something that the court was ordering her not to turn over.
I don't think on this list that there are, I mean, is there anything that y'all specifically had an issue with?
Ms. LeBeau, or do you have any concerns?
The probation officer raises her hand with a crucial clarification. She lists chronologicals, detailed logs of calls, visits, drug tests, and reports that weren't explicitly named in the subpoena. These records can paint a full picture of Sanchez's life under supervision, far beyond just a single arrest. The defense argues they're essential and legally discoverable, while the court wrestles with how much is too
If
much.
there's,
Make the court aware of.
Your Honor, just with the clarification of, our departmental chronologicals, which include, anything that pertains to the case that happens, chrono telephone calls, auto-generated, appointments, reminders, office visits, drug tests, anything that we enter into the system. But those are the chronologicals through the probation office, as well as releasing of the jail logs, his sex offender verification, interlock reports, because those were not listed on the subpoena, as well as the offense report through DPS, which was released to me and my under a supervision officer. So just to clarify, as to those items specifically being released that were not listed, with the exception of the offense report.
Your Honor, we don't have to list those. We filed a 3914 discovery request. This was belt and suspenders because we didn't get any of the information relating to probation in our 3914 motion originally. I would also note that the chronologicals.
well, and these aren't the reason you didn't get any of those is because those aren't his, they're theirs. And so they're not, I don't think Mr. Nichols has the ability legally to make probation give them those. I think once we talk it out though, I think whatever Mr. Nichols, y'all get together, obviously offense report, if y'all have the offense report and you don't even have it, then you need to get, I mean,
Right,
that's,
I mean,
that's great.
it's all
Everybody can
stuff-
get the information in an amenable way. So let's do that. Y'all sit down. I want everything that you have that is, I don't know that there's anything I can think of that would be,
Unless, I mean, I guess
Not-
notes may be work product, but I'm not real,
that's what I'm thinking about, but it's
Not
not
too
really
concerned.
attorney's notes, and so I don't know that that would
I
be an
would object
issue.
to that, Your Honor, on the grounds it's not attorney work product. It is merely work product of an employee, and it is discoverable and relevant to the case.
And that's what I just said. You seem very frustrated, and I'm not sure why. I mean, I don't know,
The tension reaches its peak. The defense attorney accuses probation of stonewalling discovery, even claiming they repudiated production entirely. The judge, visibly frustrated, interrupts sharply, warning, "Do not talk over me." This is a striking moment where the attorney's fiery advocacy risks crossing into outright disrespect. The judge makes it clear, being argumentative with probation, the prosecutor, or even the court itself won't help Mr. Sanchez. In fact, it might do the opposite.
I'm confused why there's pushback at all on any request for a 3914 discovery when he's constitutionally allowed to access those files. It should just be produced by probation without a fight. And we got a letter anticipatorily repudiating any production of discovery, and we had to file a motion to compel to that effect.
Well,
And that is alarming to me that we would have to even compel anything under 3914.
this is not something that a lot of attorneys have done in our cases. And so if there is something, if you'll sit around and watch today how everybody gets along, hold on.
Yes,
And the last thing you want to do is talk over me.
Yes, Your Honor.
So I'm standing here, or sitting here saying that I agree with you, and you're still being argumentative, even towards me. And that's not going to get you anywhere. Hold on. Being argumentative with Mr. Nichols isn't going to help Mr. Sanchez. Being argumentative with these ladies isn't going to get you anywhere. I agree that you're entitled to this information. I just think there's a better, less argumentative, defensive way to do it. They were told to do what they were told to do because their understanding of the law is what it is. So I don't disagree that we needed to all get together, but it just needs to be taken down a notch. So I want this stuff turned.
In the end, the judge orders a compromise. Probation must hand records to the prosecutor, who will then upload them into the discovery portal, ensuring transparency and accountability. It's a solution that saves face for all sides while keeping the process orderly. For Juan Sanchez, the fight isn't over. His future on probation or behind bars will depend on what those records reveal and how persuasively his attorney uses them.
Over to Mr. Nichols, and then Mr. Nichols will turn it over as discovery. I'm not going to have probation start turning it over to the individual attorneys in cases, because I think the proper way to make sure it's in the portal, that everybody knows what the discovery is that they've received, so that it's electronic when you sign your any type of documentation, whether it's at a hearing or a plea or a trial of what you've discovered, that it goes through that portal so everybody knows what everybody's got. So y'all get it to Mr. Nichols. Mr. Nichols will put it in the portal, and then you will get it. Once you get that, if there's something that you think is not there, then contact us. We'll have a hearing if necessary. Contact Mr. Nichols. Hey, what about this? If it exists and he says no, then let's have a hearing about it. Okay? So y'all get that done, and then we'll reset the case for just an announcement in what, a couple weeks or so? Fine with that?
Yeah, that should be fine, Judge. We'll be able to
Okay.
get everything scanned in and provided through the portal.
Perfect, thank you. All right, y'all are all excused.
Evidence be needed at
I'm
that
sorry?
time?
No, ma'am, if you'll just get what you need to Mr. Nichols, unless you are personally subpoenaed to be here for a hearing. Now, and on that date, we won't have a hearing on that date. So if we come in and there's pleas of not true, and we're gonna have to have a hearing, we can come in on that date, enter pleas of not true or true to certain allegations, then we would reset it for a court date. And at that point, if you need to be here, let her know. If you need a subpoena, then you can get a subpoena. If you just need us to let you know you need to be here, then we can do it informally. You just let us know, or let Mr. Franklin or Mr. Nichols know what your employer will require for you to be here for an actual hearing. Okay?
Yes,
Good?
Your Honor.
All right, thank you, y'all.
Thank you.
If you found this case as shocking as we did, hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns.